Thanks, Skip, for that introduction. And I'm very happy to be Nikolai's dad. So if you want to ask about Nikolai and our granddaughter, Greenlee, I have pictures. Just one thing, if you're an attorney and you would like CLE credit, we applied for it. Presumably they'll vote on it next week. I have forms here, so just go ahead and fill them out. We'll send them in and see what happens. Hopefully you get an hour. So Terry and I have been doing this Supreme Court review for the last couple of years, and thankfully this year it's on the first Monday in October, which is the big day when the court term opens. So what we'll do is then spend a few minutes, and I really do mean a few minutes, talking about last year, but really focusing on this year, upcoming, and answer your questions, because this year, I think, has all the hallmarks of one of those historic terms for a number of reasons. Part of it is what happened last year, where the court went through an entire term almost with 8 justices, and so the court tended not to choose controversial cases or disposed of some of the ones in a way that sought some kind of middle ground. Now that there's 9 justices, the cap has been taken off, and most people expect many of those issues to come to the fore. I want to talk about one area. It's really one case and a case that didn't happen, and that's in the area of religious liberty from last year. The decision in Trinity Lutheran versus Comer, which was toward the end of the term, had a significant impact for potential future cases. Now, the decision itself was an 8-to-1 vote. And in this case, the state of Missouri offered schools a grant for different things. This particular religious school, Trinity Lutheran, wanted the money for playground resurfacing to make it safer. Okay? The Missouri state constitution, however, had for years prohibited state money from going to religious schools. And there was a decision the Supreme Court made about 10 years ago that seemed to support those kind of state constitutional bans. In this case, however, the Supreme Court said, no, really, if you're giving out money for things like playground resurfacing, you can't discriminate against religion. You can't discriminate on the basis of religious identity. And again, 8 justices thought that was the correct rule. But here's the really curious and interesting thing. The majority had a footnote, footnote 3, which said, we're not discussing anything other than money for playground resurfacing. And 3 of the justices agreed with everything in the majority opinion except that footnote. For at least 3 of those justices, they believe that the more general principle should be that the state cannot discriminate on the basis of religious identity whenever it's giving out money, even if that money might go toward religious purposes. And so therein is the key to what Trinity Lutheran means in the future. Will it be limited to state money that goes for non-religious purposes, like playground resurfacing? Or will it be available to religious schools for religious purposes, subsidizing teacher salaries, buying textbooks that might include religious material, paying other things that can be easily diverted to religious uses? So there's where the future battleground will be about the Trinity Lutheran case. Okay? Now, the only other thing of interest last year in the area of religious liberty was what didn't happen, and that was with the case involving the Little Sisters of the Poor. Before there were 9 justices, the case was on the docket. The Supreme Court was going to decide if the Little Sisters of the Poor were entitled to a religious exemption for filing a notice with the Department of Health and Human Services that they wanted a religious exception to the Affordable Care rules. And then at some point the court said, you know what, go back, talk this out. This was after they had oral argument. go figure out whether there's any way you can come to an agreement. So that's sort of back there somewhere in the pipeline. Other than that, the court's term was fairly ordinary, some might say boring, but this year promises to be a much more interesting year. Right off the bat, today the court was supposed to hear the Trump travel case. Given the third iteration of that policy, the court has asked for, they've removed it from argument, and they've asked for a discussion whether or not the case is moot, whether the new policy takes care of all the issues that were raised in the appeal in front of the court right now. So it's not clear whether that will ever get to the Supreme Court. If it does, the fundamental issues will focus on questions of equal protection and also a question on religious discrimination. Likely that the court can find ways around some of those issues. It's hard not to confront the religious question up front. So it's not clear that's actually going to get there. And it seems to me that many of the issues have been mooted by the third policy. So we'll see what happens in the next couple months.
Okay, I'm going to talk about a case also coming down this coming Supreme Court season. And I think John and I are in concurrence that this is probably the most important case that the court's going to be deciding this year. Although I have heard that criminal defense lawyers think that the Fourth Amendment one is more important. John's going to talk about in a minute. The one I'm talking about is Gill versus Whitford, which is a case about political gerrymandering, an issue that has been consistently a problem or not a problem, depending on your political persuasion, in certain states in the United States. Finally, the court is taking a case that it looks like it may actually decide the merits of whether a state has gone too far in how it has politically gerrymandered its state legislature. So this is about the state of Wisconsin, who, as a result of the 2010 census, did some redistricting in 2011 with exceedingly favorable results for Republican candidates in both their 2012 and 2014 elections. What makes this case interesting is that for 30 years, we haven't seen courts overturn redistricting plans based on political gerrymandering, although there have been multiple attempts by litigants to try to get changes based on political gerrymandering. This case was heard by a 3-judge panel of federal district judges who found that Wisconsin's system was indeed unconstitutional under both the Equal Protection Clause and the First Amendment Clause right to freedom of association. So 2 grounds for finding that the way they gerrymandered in 2011 was unconstitutional. The reason we haven't seen cases in 30 years, or in part, this is a more recent case, is that the court has been unwilling to hear these cases on the merits. In 2004, in the case of Wyeth versus Jubilario, the plurality of the court held that cases involving political gerrymandering were non-justiciable political questions. Essentially, what the court ruled was that they don't have a standard under which to decide whether a gerrymandering based on politics was indeed inappropriate or not. There was no good standard out there to decide, and so they had left it to the political branches, in these cases state legislatures, to decide how to divvy up their redistricting when it came to censuses every 10 years. However, as in many cases, Justice Kennedy wrote a concurrence. We have a plurality of 4, and then we need Justice Kennedy as our 5th vote not to hear the case on the merits. And Kennedy said, although there isn't a standard yet, he thought that there could be developed a standard that could be used in these cases where the court could step in and say, yes, this is unconstitutional, you have political gerrymandering that's just unconscionable and violates the Equal Protection Clause. Welcome the state of Wisconsin, which has an incredible fact pattern, but I'm going to wait for just a second to tell you about that. The panel here did adopt a 3-part standard that may or may not meet Kennedy's standards for an applicable standard to use here. That 3-part standard essentially set out that there was an intent to political gerrymander, that there was the impact of actually political gerrymandering, and that there was no legitimate other reason for the way that they had set up the legislative districts, okay? And in this case, the three-judge panel said, the plaintiffs in this case have made out that this indeed was a political gerrymandering case that met those three criteria. So let me tell you how successful Wisconsin was in political gerrymandering. As a result, and this is from actually the actual lower court case, in 2012, Republicans garnered 48.6% of the statewide vote in electing the assembly in Wisconsin, and yet secured 60 of the 99 seats in the assembly. So they got over 60% of the seats in the assembly with less than 50% of the vote. In 2014, Republican candidates increased their vote percentage to 52%, and in that case secured 63 out of the 99 seats, which is about 2/3 of the assembly seats with just a little over 50% of the vote. With those kinds of facts, and if you actually read, the legislative redistricting group had their own statistician who figured out exactly how they could redistrict to get the most Republican votes. It was very obvious that there was an intent to consider trying to get as many stable Republican districts as possible, and then, of course, was successfully doing so, that the court did indeed find that this did violate the Equal Protection Clause and the First Amendment Clause. So we will see whether Justice Kennedy agrees that this is a workable standard that was indeed violated in this case. There are other states that have also some significant political gerrymandering, among them Pennsylvania, North Carolina, and Texas. So it will be interesting to see if this indeed becomes an applicable standard that the court is willing to apply, whether we see additional cases in other jurisdictions coming as a result of it.
And I think it's obvious why we think that's the most important case in the term, because it really goes to the heart of democracy. Mm-hmm. And we're at the point now where when you get such a disparate result, there really have to be some sort of solutions. The problem is, one would think that legislatures would seek those solutions because it would be fair. But notice neither party really has an incentive to do that, because the party in power doesn't want to change, and the party out of power thinks, well, when we're in power, we can do the same thing. So in many ways, it's going to be up to the court to deal with that problem, even though there are lots of policy and legislative solutions to it. I think it's just one of those moments where the court has to break that logjam.
Just as an aside, they did not mandate a remedy. They told the legislature, they sent it back to Wisconsin and said, you've got to come up with a better redistricting solution, actually by November 1st of 2017. So that was the lower court's ruling on that particular case.
And so speaking of Justice Kennedy, here's another case where he matters. I used to have a PowerPoint slide for this presentation that said, Tony, Tony, Tony. For those of you from the 90s will remember that, because it really is his court. He really is the fulcrum around which many of these cases turn, in lots of ways. So the court takes 1% of all the petitions to them. So anytime a petition gets on their docket, it means it's going to have important and significant effect on the law. Anytime a case sits in their queue over and over and over again until they decide to take it or not, means something is going on with that case. The Masterpiece Bake Shop case is one of those that sat on their agenda for weeks. It was passed over a total of 15 times without decision until they finally said, yes, we'll take the case. And that's in contrast to similar cases. So let me tell you about the Masterpiece Bake Shop, and you'll see why it could be a significant case. So it revolves around the sort of almost iconic baker, photographer, wedding planner who doesn't want to, for religious reasons, serve customers for same-sex marriages. In this case, it's the cake decorator. But previously, the court has denied the photographer who sought the same protection. So between the photographer case and this one, something has changed. At least 4 justices on the court, that's all it takes, have agreed we want to hear this case. So the Masterpiece Bake Shop case arises in a situation in which the state, in this case Colorado, has a public accommodations law. And that public accommodations law says public accommodations, restaurants, hotels, businesses, etc., cannot discriminate on the basis of, list the usual protected categories, and in Colorado it includes sexual orientation. The Masterpiece Bake Shop is a public accommodation by the Colorado law. That person has religious scruples for participating or against participating in same-sex weddings. A same-sex couple came to him for a cake. He said no. They went to the Colorado State Agency. The Colorado State Agency then said, you have to find the bake shop. So the owner of this bake shop argues two things. One, he says, forcing me to do this violates my rights of religious liberty under the Free Exercise Clause of the United States Constitution. And two, it violates my free speech rights by compelling me to say something with which I disagree. Okay? So his claim really has two facets. On the religion side, the lower courts have uniformly said, no, you don't have a free exercise right in these circumstances. There are two reasons. One, the court has said the law doesn't target religion. The public accommodations law doesn't target religion. It simply says if you engage in business on a neutral basis, then you have to comply with this law. And that's true, think about that, for every law that applies to us. I mean, the law, for example, of not running stop signs applies to everybody. You don't get a special get out of stop sign law card if you're late to church on Sunday morning. Because the law doesn't target religion. It doesn't say only people who run stop signs on the way to church are subject to penalty. It says anyone who runs a stop sign. And so the general free exercise rule says if the law is neutral about religion, you can't claim a religious exemption unless the law is targeting religion in its application, or it has a hybrid connection to some other individual right. And so what the bake shop owner says is, well, it may not target religion, although there are other exemptions for people that people can get if they don't have religious objections. Colorado apparently allows some people to get out of making cakes and other things if they have political objections to doing that. And so the owner says, well, wait, once you do that, you can't single out religion for not giving us an exemption. The other thing he claims is that there's a hybrid connection to my speech rights. And that, in all honesty, is the strongest argument. Because the court has been very consistent saying the First Amendment cannot make the state or allow the state to force you to say something you disagree with. Now, they can force you to make factual statements. You know, when you apply for a driver's license, you have to make some factual statements. You can't say the First Amendment can't force me to do that. But the First Amendment can't force you to make a statement of belief called a compelled affirmation or take a position on a political issue with which you disagree. And so the baker says, or the cake decorator says, wait a minute, this is an artistic thing I do. Otherwise, you could buy the cake at Kroger's, right? This is unique to me. It's an expression I'm making. I'm saying something here, and therefore you can't compel me to say something I disagree with. So that claim, I think, has the most legs. I think there's an argument against that, which is he's still free to post a sign in his window. He's still free to make public statements about his opposition to same-sex marriage. He's free to do all those things. He's not prevented from making that statement. He's just prevented from offering a commercial service and denying it to people with whom he disagrees. So watch how that turns out. It wouldn't surprise me if the court creates a speech right here and avoids the religion claim entirely.
Well, I'm going to go on again to another one that involves political rights, in this case, voting rights. So that seems to be a theme between the political gerrymandering and now we also have an important voting rights case. In Houston versus A. Philip Randolph Institute, the court is going to take up whether states can take people off the voter rolls simply because they don't vote by inactivity as a voter. The National Voter Registration Act is a federal law that sets up the process for states to clean up their voter rolls. One of the things it does prohibit is removing voters from the voter rolls simply because they failed to vote. The state of Ohio has a process in place where it sends out notices to voters who haven't voted in 2 years, asking them if they have moved. If they get no response from that voter, and that voter doesn't vote within the next 4 years, that voter is taken off the voting rolls altogether. So a challenge went out from a bunch of civil rights groups saying that this violated the National Voter Registration Act. They argued that many voters had missed those notices and had showed up to vote and only to find out that they had been taken off the voter rolls. They argued that there were tens of thousands of votes that were not counted as a result of that because the voters had to hand in provisional ballots that sometimes do, sometimes don't get counted, apparently, at least that they argued in this jurisdiction. The Sixth Circuit struck the rule, and Ohio appealed to the United States Supreme Court, which of course has granted cert in this case. Ohio is not the only state that uses voter inactivity as a basis for taking people off the voter rolls, so this could have interesting implications for other states as well. Another thing that's an interesting artifact in this case is that the Department of Justice has flipped positions on this particular case. The Obama administration's Justice Department took the position that Ohio's process violated the voter laws, federal voter laws, and the Trump administration has recently flipped on this and decided to take up the position of Ohio, that Ohio can indeed clean up its voter rolls based on voter inactivity. So again, right to votes, fundamental political rights are going to be at issue in this coming up session.
Speaking of fundamental rights, so let me go back to the Masterpiece Bake case and also connect it to the next one, and I think there's a hint that could come in either direction. So I said the speech claim in the Masterpiece Bake Shop case was the key, whether or not you can compel people to speak. There's another case the court has just taken involving agency fees, union fees in a mandatory union shop that has come back to life and could both upset First Amendment law by overturning some of it, but also offer a key to how the court might decide the cake case. And so here's what's going on. In states that are not right-to-work states, where there are union shops, obviously if you're a member of the union, you have to pay your union dues. But the court had previously held that you can't force people to pay their union dues, at least that portion of the dues that would compel them to agree with the political positions the union is taking. So the court has said you can't compel somebody to pay for, say, the union's position on health care. And so previously, the law had been that a person who didn't want to join the union but was compelled to pay what were called agency fees, which would go toward the union's collective bargaining activities, could have that portion of the fee that went to the political activities of the union deducted from their agency fee. And the court has signaled repeatedly in the last 7 or 8 years that they think that's a problem. And it looked like that was teed up in the previous term to say, no, any payment to the union that's compelled, in essence, is a violation of the First Amendment, because everything the union does is involved in some sort of policy question which the individual might disagree with. Maybe the individual doesn't agree with collective bargaining, and you're forcing them to pay for collective bargaining activities. When Justice Scalia died, however, the court said, you know what, we're not going to hear that case. Clearly, he would have been the fifth vote. So with Justice Gorsuch on the court, they have now taken a different case, but raising the exact same issue about agency fees. So I would expect the court to declare that paying agency fees, mandating the payment of agency fees, does violate the First Amendment. And how broadly they state that claim will be a key to how likely they are to uphold the cake decorator's claim. So if they say that it's anything that compels you to pay, participate in, then the decorator has a stronger case. If they say it's compelling the membership in an expressive organization like a union, then that's a narrower view and might limit the cake case. So those two are related, and depending on which one comes out first, you're going to get a key or a clue to how the court is likely to turn out. My guess is that the union case comes out first, since you've already got 8 people who are ready to make a decision. So I think that one's likely to happen first. The cake case is likely to come out toward the end of the term, because there should be a whole lot of discussion going on in the court about how that's going to break down. And so I think that one will be a last week in June decision.
So I'm going to pick up with another labor case, and that's one involving whether employers can force collective actions by employees to go through arbitration, or actually not even allow the collective actions at all. For those of you who don't know, the Federal Arbitration Act is a federal act that favors arbitration clauses. And in recent years, the Supreme Court has given the FAA incredible power. It has used it in cases to prohibit people in consumer contexts for bringing class actions, also from bringing even class actions in the arbitration context. So the Federal Arbitration Act has got lots of muscle in the recent Supreme Court terms. However, it's running up against, in this case, the National Labor Relations Act, which explicitly protects employees who are engaged in concerted activities. So the question becomes, which one's going to win here? Are employees going to be allowed to bring collective actions pursuant to the NLRA, or is the FAA going to continue to flexing its rather considerable muscle in favor of arbitration of employee claims? And we'll just have to wait and see which one wins.
Now it's time for search and seizure. So I'm just going to list the 3 cases that are on the docket. They're interesting, and I think they could go a long way. But here's the thing about search and seizure law. It's incremental in very tiny, tiny steps. So for lawyers, that's really cool. Sometimes for ordinary human beings, you wonder what exactly is going on here. And some of these are like that, but they really do matter. So search and seizure law comes in the 4th Amendment that says the state can only conduct reasonable searches of your person's property, papers, and effects, or if they have a warrant. And there's this huge set of rules about the exceptions to that. So when do you not have to get a warrant? When is it not a search? All sorts of things. Typically, 2 things are at issue. One is whether or not the police activity invades a privacy interest. And in recent years, the court has said, yeah, but it also matters whether they've trespassed on a property interest. Now, often the 2 come together, right? If the police burst into your house by knocking the front door down, they both trespassed and invaded your privacy. But sometimes the 2 can be separated. If the police put a little beeper on your car that can allow them to electronically follow you, they haven't really invaded your privacy because your public, where you are in the public isn't private, but they have trespassed on your car. So the court has added a number of these interesting features. So there are 3 cases now that raise questions of privacy and trespass. One is whether somebody has a reasonable expectation of privacy in a rental car if they're not listed on the rental agreement. So in this case, somebody's driving a rented car, he's not on the agreement, they stop him for a traffic violation, let's assume that's true. They then say, you know what, we want to search your trunk. And he says, well, you can't because I'm not on the rental agreement. They get suspicious, they open the trunk, they find a body and body armor. I don't know how it got there, says the driver. eventually he says, look, you didn't have a right to search that trunk because I had an expectation of privacy in the vehicle because I'm driving it. So they have to decide whether or not he's got that expectation of privacy if he wasn't on the rental agreement. Speaking of cars, there's also a doctrine called the automobile exception, which means that if you're stopped and detained and there's a fear that the car is going to disappear because cars are mobile, or that evidence will be destroyed, or there's independent probable cause to search the car, the police can do that without a warrant. So in this case, somebody was leading the police in a high-speed chase. He gets away. They get on Facebook. They find out where he lives. They go to his house. They notice in his driveway there's something covered up. Looks like a motorcycle. They walk on the property, pull up the cover. They run the license plate on the motorcycle. They discover the motorcycle was stolen. So the question is, did the automobile exception apply to that motorcycle? Was it readily mobile? Was there otherwise probable cause to search? So you've got to decide whether or not that involved both a trespass, a violation of property rights, or an invasion of privacy. And then finally, the one that might matter to most of us, because I don't think many of us are going to be dealing with having stolen motorcycles on our property, is whether or not the police can get cell phone records from your cell phone provider without a warrant. And that involves something called the third-party doctrine, which historically said if you turn over otherwise private information to a third party, you lose your right of privacy in it. And so the theory here is that when you sign up with a cell phone provider, they collect lots of data, right? I mean, if you get the detailed bill, you go online, they have a record of all your phone calls and when you called them and how long they lasted. But you've turned them over voluntarily to this third party. Do you lose your interest in privacy in that information such that the government can get it without a warrant? So that involves the third-party doctrine. The last couple of years, the court has said the state has to have a reason to search your cell phone when you're arrested, and if they don't have a good reason, they need to get a warrant. So does that also apply to this third-party information that you've turned over to your provider? That's going to be an interesting case, and that has some potential to be widespread.
So now for something completely different, betting on sports. Okay, so I've been to Las Vegas. I'm not a betting person. I work too hard for my money to watch it be frittered away, but I would like to bet on sports. I think I can beat that spread, okay? And believe it or not, the court is about to take up a case involving the state of New Jersey and its extension of allowing betting on sports within the state. So you probably already know that you can bet on sports in Las Vegas. If you've been there, you know you can bet on sports in Las Vegas. However, the Federal Professional and Amateur Sports Protection Act bars states from repealing existing laws that ban sports betting. Most states have in place laws that ban sports betting, okay? With the exception of Las Vegas and I think it was Oregon and Delaware, most states at the time this law was enacted had laws that banned sports betting. New Jersey, interestingly enough, was given a year after that law passed in which to repeal its law that banned sports betting. Didn't quite make it within that year, did it several years later, and therefore when it did go ahead, and actually it took a constitutional amendment by the people of New Jersey to permit sports betting, and then the legislature, of course, enacted laws pursuant to that constitutional amendment, they actually got themselves sued by 5 sports leagues to enjoin the New Jersey law, arguing that it violated the federal law that prohibited repeals of such legislation. New Jersey, in response, argued that the federal law violated something called the anti-commandeering principle. So this may look like it's only about sports betting, but it's actually about the authority of the states versus the federal government and what the federal government can make states do. The anti-commandeering principle most notably comes out of a case called New York versus United States, where in 1992, the federal government said, the United States Supreme Court said, you can't make states take possession and title of low-active radioactive waste against their will. Okay, that's basically the gist of that case. Out of that came the general principle that you can't make states legislate. You can provide carrots. For example, we'll fund this program if you go ahead and set it up. You can also legislate on the entire area. For example, you can dictate nationwide what the policy will be on something as long as it's within Congress's authority to legislate in that area. However, you can't make states do your business as the federal government. Another case where this came up was in mandatory background checks, where the federal government was making the states do that for them until they got their system up and running, and the court once again said you can't make states do your job. Okay, you can't force them. So New Jersey's arguing here that they are being forced to legislate or keep legislation in place in a particular way when they in fact want to legislate to permit this betting. Okay. So essentially, the case, we're looking at whether or not this violates the 10th Amendment, reserved powers to the states, and whether the federal government can indeed prohibit a state from legislating in an area of particular state concern. Another thing that's interesting about this case is that we both think they're going to lose, New Jersey, don't we? So it's a pretty, if this case goes forward, I think it's going to be tough for the states to argue that they're not being commandeered. I mean, it's going to be hard for the federal government not to say they're being commandeered all over the place. But nonetheless, New Jersey's taking a stab at it, and the court is granting cert. Sure, I can talk. Oh, we're backtracking now. Okay, so we're going to talk about one case that actually has already been decided from last term. It's a little idiosyncratic on our part, only because it involves the state of Arkansas. So it's the one interesting Arkansas case that came down last year, Pavin versus Smith, which was an appeal from the Arkansas Supreme Court. The Arkansas Supreme Court had ruled that the state was not required to list both members of same-sex married couples on their child's birth certificate. The United States Supreme Court summarily reversed. Okay, so a summary reversal generally is reserved for lower court cases that are clearly in error. So this is kind of like the United States Supreme Court saying, Arkansas Supreme Court, you really got this one way wrong. The United States Supreme Court held in light of Obergefell versus Hodges, the case that upheld the right to same-sex marriage, that this deprived married same-sex couples of the same rights to be listed on their children's birth certificates as married opposite-sex couples already had. Thus, this was unconstitutionally discriminated against same-sex couples. Now, there's one thing that's really interesting about this case. It was a per curiam decision, which means there was no justice who wrote it was on behalf of the court as a whole. However, there were 3 dissenters in this case. The dissent was written by Justice Gorsuch, and both Justices Alito and Thomas joined. Interestingly absent was Justice Roberts, who authored a dissent in Obergefell. So he actually came out in that case against the right to same-sex marriage. Yet, when confronted with a case about the rights of same-sex couples to have their names on their children's birth certificate, he actually upheld that right. And Dean DiPippa and I have opined that Justice Roberts is somebody who follows precedent, even if he disagrees with that particular precedent, and this would be consistent with what we've seen him do in other cases.
We think Justice Roberts really, I called him an institutionalist, and I think he believes in the institution of the United States Supreme Court. Even his decision in the Affordable Care Act case, where he upheld the individual mandate as a tax, seems rooted in his concern that the court would have appeared overtly political. Mm-hmm. And so I think this is a good indication that he really is an institutionalist, that he will follow precedent. Lots of historical examples of justices who have done that. I think he fits very neatly into that package.
Coming attractions? Are we ready for coming attractions?
Or opened it up to questions.
You want to do? Can I do one coming attraction? Okay, so you know, the court's going to grant probably certain like 70 cases, and so far it's done like 33. So we're only halfway through what they will probably end up granting in the course of this year. One area that there's been a lot of talk about whether or not they will grant cert in is whether Title VII of the Civil Rights Act of 1964 is applicable to discrimination claims based on sexual orientation. There is right now a split in the circuits on this issue, and many folks are opining that, indeed, the court will grant cert. So just to give you a little background on this, Title VII of the Civil Rights Act of 1964 prohibits discrimination based on race, sex, national origin, religion, and color in employment. Early on, in cases in the early 1980s, courts confronted with whether this statute covered sexual orientation discrimination universally said no, it didn't. Sexual orientation is not listed as one of the prohibited statuses. It is not covered by this law. If Congress wants to do that, they have to amend it. In 1989, the United States Supreme Court issued a decision in Price Waterhouse versus Hopkins in which it recognized that sex stereotyping can be actionable as a form of sex discrimination under Title VII. Well, smart lawyers figured out, well, wait a minute. Sexual orientation discrimination often takes on the form of sex stereotyping. And many plaintiffs started using this sex stereotyping discrimination as a basis for challenging discrimination based on sexual orientation. However, they had to cabinet and make sure it looked like sex stereotyping. So they had to come up with clever ways to link it into that sex stereotyping case that came out in '89. Lo and behold, the Seventh Circuit took it up en banc and said, let's just stop this. Title VII does indeed cover sexual orientation discrimination because it is by its nature a form of sex stereotyping. We no longer have to try to cabin these cases and make them look like sex stereotyping. It is basically a form of sex stereotyping when that discrimination is inflicted on people in employment. The Second and 11th Circuit, however, have disagreed with that position. And the plaintiff, actually there's an en banc hearing pending in the Second Circuit still on this issue. They have yet to rule on it en banc. The 11th Circuit, however, in Evans versus Georgia Regional Hospital, also ruled that except the Title VII doesn't cover it. And the plaintiff in that case has petitioned for certiorari. So there's some thought that because of the split between the 7th and, at the current time, 2nd and 11th Circuits, we will see the court taking up whether or not Title VII does just plainly apply to sexual orientation discrimination. And now I'm ready for questions.
And let me just talk about Justice Kennedy one last time. We mentioned it's his court, and let me locate him in some of these cross currents, because the Title VII question, the religious question, they're really kind of a combination of things he cares about, free speech questions. So he's been a very ardent defender of free speech, almost an absolutist. So in the Masterpiece Bake case, you have to decide whether that's going to be important. But he has also written every single important Supreme Court decision on gay rights since the first decision in Romer versus Colorado 25 years ago. So which of those take precedence in his jurisprudence when they come together? Is it his almost absolutist free speech claim, or is it his very, very strong and eloquent defense of individual dignity in Romer, Lawrence, Windsor, and Obergefell? And I think the cake decorator case really presents a dilemma for him in terms of his jurisprudence.
He's going to have some cognitive dissonance.
Yes, indeed. Now it's time for questions. Either that or I'll call on one of my students.
Yeah, we got time for a few questions. We've got about five minutes for questions, so there we go.
I just want to know if either of you have an opinion on what the impact of Justice Gorsuch will be in the coming session.
I think there's one area where it's pretty clear, and that is in areas of religious liberty. When his track record is pretty clear. Some of his dissents, for example, in Pavin and some other things he said suggest to me that he will be a reliable vote with Alito and Thomas. Probably the best comparison would be that I don't think he'll be much different than Justice Scalia would have been on many issues.
I would agree with that. I think he's going to be a very reliable conservative justice, unlike, Kennedy and Roberts do things that I would think are a little bit off of their conservative viewpoints here and there.
And what's unusual about him is how assertive he's been for a new justice. So he's not shy about taking positions and staking them out.
Yes, Kathleen.
Do you all have any thoughts as to whether there'll be any resignations during this session or after this session is over with?
Among the justices?
Yeah.
I don't. I mean, I think Ginsburg is hanging on. I think
Right.
There's a whole bunch of them who are in their 80s.
There
But
have been rumors that Justice Kennedy would resign. Clearly, that would be a major moment.
Yep.
I don't think you would find any of the 4 so-called liberals resigning anytime soon. Justice Kennedy is a possibility. Well, and just to add on, Justices Roberts and Alito and Thomas are relatively young for Supreme Court justices, so I think they're in good health and they seem to be happy doing what they're doing.
Yes, ma'am. Wait for the microphone. It's coming right at you, please.
You mentioned a law there that where the federal government can't make the states do something. Why are they? How's that working with the states and the immigration laws? I'm not a lawyer.
So, I mean, where federal law can cover an area, and certainly the Congress has the authority over immigration and naturalization, so states will have to follow suit in areas of federal concern. Like I said, this doesn't work very well very often for states, this anti-commandeering idea. It's only so far worked with gun background checks and low-level radioactive waste. So.
And on things like immigration law, the Constitution also says that when the federal government has the power over something, and they've exercised it, that prevents states from doing anything that interferes with or conflicts with that. So in immigration, many states are trying to create their own policies, but because Congress has the immigration power, states can't conflict with what Congress has done.
Yes, ma'am. Right here.
Excuse me. Will the decision on the third-party phone records have any ramifications or effect on the seizure of telephones at the border for people coming back from overseas trips or anything like that?
The third-party case, no, because that's seizing the property owned by the person, not turning over the contents of the phone. So that won't have any effect on it, I don't think. Now, maybe the car cases might have some effect depending on where the phone is found, whether it's in the pocket of the driver or it's in the car itself. Those could have some impact on that part of it, but not the third-party case.
Yes, sir, right here.
Mr. DiPippa, a little earlier, you said that the Supreme Court doesn't want to appear to be overly political. That brought a smile to my face. When I was going to school more than a few years ago, I and my classmates were taught that there were 3 branches of government, both on the federal and state level. It aggrieves me to say that I'm of the opinion in the year 2017 that we only have 2 branches of government. We no longer have an independent judiciary. And I think there's ample evidence of that, both on the federal and state level. And again, I'm sad to say that, but I think that both the court on the federal and state level are more arms of the political parties. They're no longer independent thinkers. We can pretty much predict how almost all of the justices on both of those courts, how they're going to come down on cases, and that makes me sad.
Let me just defend my characterization of overly political, and it's appearing to be overly political. There is some interesting data that suggests that the political parties have gotten much better at vetting their nominees in recent years than they were in the past, which may account for why you tend to get nominees who end up voting the way you could have predicted during their nomination.
Can I just add one thing that might make you a little less cynical? So we have a fairly divided judiciary at the federal level at this point. You know, it's roughly half Republican appointees and Democrat appointees, and yet the vast majority of Court of Appeals decisions where you have 3 justices are unanimous. So in many cases, Republican judges and Democratic appointed judges are agreeing on the outcomes of these cases. It's only in the ones we focus on because there is room for political, decision making or politics to influence decision making that we end up talking about. So the vast majority of cases are unanimous and are pretty straightforwardly decided by a mix of both Republican appointees and Democrat appointees. Little less cynical? Make you feel a little better? No.
And let me just piggyback on that to hope to make you less cynical. Remember, only 1% of the petitions to the Supreme Court get decided, so presumably those are the hardest cases and the ones people can disagree over. And so, again, we focus on the ones at the Supreme Court because those are the ones that get the most attention. The vast majority of cases, Democrats and Republicans handle identically.
Yes, our final question right here.
In the past month of September, the Equal Employment Opportunity Commission has filed 2 suits in federal court as violating the Title VII of the 1964 Civil Rights Act, one in Nashville and one here in Little Rock. In the event there's a decision that goes counter to the defendants, do you foresee an appeal of that all the way to the Supreme Court, if need be, regarding right-to-work laws that presently exist in southern states?
I'm not sure I know about those cases, so it's hard to make a prediction about them. But most statutory appeals are going to be vetted through the department, and they're going to pursue whatever department policies there are at the moment. So that's going to vary from administration to administration for sure.
Yeah, and we certainly have seen some flipping between the Obama administration and Trump administration, so you may not see these cases get appealed if they actually are favorable to defendants, or we'll see.
Dean Beiner, in the New Jersey gambling case, in looking at that, it specifically referred to sports betting at racetracks and casinos.
Yep.
If New Jersey wins, does that apply to Oaklawn and Southland?
Well, certainly it would depend on what the existing laws are in Arkansas with respect to sports betting, but it would open up the opportunity for more states to allow sports betting in their various, casino or whatever racetrack settings. Yeah, it would open that up.
By the way, I should add that Terry is a New Jersey girl.
Yes.
And so that case was particularly interesting to her.
I'm telling you, I can beat those spreads.
All right. Let's give Dean DiPippa and Dean Beiner a round of applause. Thank you very much.